Good evening, everyone. My name is Naomi Birundu, and I'm the court assistant for this session. So just before we start, Simon Wekesa can do the photo session.
All right, thanks a lot, Naomi. Yes, kindly let us all open the cameras so that we can have a virtual photo. Great. Yes, kindly let us open the cameras. The last one. All right. Thanks a lot. That's all.
All right. Welcome to the fourth quarterfinals round of the Green Law Global Initiative Climate Justice International Moot Court 2026. The matter before this honorable court for today is between Egerton University, representing Azania, and the Catholic University of Eastern Africa, representing CECA. The honorable bench for this session will consist of Judge Matthew Emukule as the presiding judge, Judge Eric Theuri, and Judge Grace Njoki. I will now respectfully invite the honorable judges to take the bench. So the court is now in session, and I respectfully hand over the proceedings to the honorable presiding judge.
Judge Emukule, are you with us? Presiding judge, are you there?
Right there. Good evening,
Yes,
fellow
good.
judges and participants.
Good evening,
Welcome the fourth session between Azania, Egerton University, and CECA, and Catholic University. May I again have the names of counsel for Azania?
Much, Your Excellency. I am Gloria Ogwell, the first counsel for Azania, and my co-counsel is Joshua Kebati.
Thank you, Gloria. And Catholic University, good evening.
My name is Nick Kimathi. I am the lead counsel for CECA, and I am joined by my brother Timothy Kamore as co-counsel equally for CECA.
Thank you very much, counsel.
Just a reminder, sorry to interrupt, but the counsels and the judges are required to have their cameras on throughout. Thank you.
You can see me? So we start off with Gloria, and the first issues will be raised by fellow Judge Theuri.
Presiding judge, with your kind permission.
Yes.
This is Judge Njoki. Unfortunately, under a blackout scheduled by KPLC, so I cannot switch on my camera, but I am following the procedures and I'm ready to proceed. Thank you.
Thanks, Judge Njoki. Thank you. Brother Judge Theuri, today's discussion, today's quarterfinals, basically questions from the bench to the participants. I see this first questions come from Judge Njoki. Even you see her, she's following the proceedings. Judge, your first go.
All right, thank you. I can proceed with my questions?
Yes.
All right, so these are questions for Azania, Ms. Gloria, Mr. Joshua. So initially you argued that the TWCCA is proportionate. Help the bench understand how does this law remain proportionate in practice, particularly given the burden it places on small-scale traders and informal actors.
Much obliged to Your Excellency. Thank you so much for the question. On the proportionality test, Your Excellencies, I want us to first go to the case of Ox versus the Republic. It is one of the most landmark cases that established a proportionality test. And it established that proportionality, yes, it is a legal concept. However, it should be evaluated based on the circumstantial things that exist in the fact. So the question we will be asking ourselves is, what are the facts that exist in our matrix, and what are the laws that we are imposing? And the fact is, we have children at the coast who are dying. We have flooding in the country. We have waterborne diseases in the country, and we have respiratory diseases that may occur in the country. And this could mean that this will now take us to the law since we have the facts. The case of Tatar versus Romania upheld that environmental concerns can justify to limit some economical rights so as to achieve and protect the climate. Also, the case of Hungary versus Slovakia established that we balance must strike a balance between economic protection and environmental protection. Therefore, it's our submission that based on the imminent danger that existed in the fact sheet, it is only the Tweaker Act that would have remedied the situation. Thank you, Your Excellency.
Judge Joki?
Mr. Joshua, thank you. I have no further questions. Thanks.
Very good. Brother Judge Theory,
Yes, presiding judge.
any questions to Azania?
Yes, presiding judge. Let me just ask a follow-up question.
Yes, thank you.
With regards to the question that fellow judge fellow judge Njoki posed, and this goes to Azania in terms of your arguments as regards proportionality of the law. You all know that there is the principle of common but differentiated responsibilities, and this takes into account the respective capabilities of the different actors when it comes to the implementation of the climate change treaties. So my question is, in view of this legal and international principle, and the fact that the state, under the due diligence requirements, Azania was required to have taken measures to prevent the importation. And so what is happening is that the enactment of the Act, the TWCCEA Act, is intended to, in a way, stop the pollution arising from importation of the apparels. So it is from the facts we can see that a significant portion of the population relies on this industry for purposes of their economic well-being. So that taking into account this principle, how then would you want to convince the court that then the measures meet the international the threshold for proportionality?
Much obliged, Your Excellency. Thank you so much for your question. I request this court to go to the case of Pearl Mills case, and this case established that a state cannot be held liable for the things that are beyond its capacity and control. So whenever we are faced a question of common but differentiated principle, the first thing we're supposed to see is what is the capacity of the state and what are the measures it is taking according to the capacity. Paragraph 1 of the fact sheet clearly stipulates that this is a third world country with 48 million people. And so being a third world country, and the question is it taking measures that a third world country is supposed to take? The first one, the answer is yes. What is the first measure that it takes? It carries a government commissioned audit. The second one, it carries a scientific research. The third one, Parliament sit down and enacts a legislation. And all these processes are checked by the judiciary. Also, Your Excellency, kindly I want you to request, though it cannot be seen from, I want to use this chart to guide the court on different responsibility. Therefore, I want to mention them. The first one on how these second and apparel flows are distributed. The first one, we have the donors from the West, we have collection organizations, we have the companies which are exporting to our country, then we have importing companies from our country, we have a wholesale trader, then we have local distributor, and lastly, we have the consumer. And the extended producer responsibility strikes a balance by giving accountability mechanism within all these people in this matrix. Therefore, it does not just impose to the local distributor alone, but everybody, including the first person who handles the second-hand clothes.
Thank you, Mr. Joshua, for your response. Presiding Judge.
Please carry on. Sorry, I was a bit out of focus for some time. Thanks, Judge. My question to Judge, do you have another question?
Judge, if you can ask as I try and check my notes in terms of the issues that have been submitted upon.
My question goes to Gloria.
Or, Presiding Judge, I could proceed now that I have my question.
Oh, thank you.
To Gloria. Gloria, the area that I wanted you to clarify is you know that the due diligence principle operates on the basis that there is a duty on the state to take measures to prevent a significant risk to the environment. So my question is, what is the environmental context that gives rise to this significant risk to the environment? And I say significant risk because that's what the pulp mill scales did set out as a threshold, so that when we are looking at the issue of environmental, the risk, then it must be taken in the context in which the activity is being carried out. And I wanted to first understand that context and whether there is other measures that could be undertaken by the state to mitigate that risk without possibly relying on the TWCCA.
Thank you so much, Your Excellency, for the question. It is my submission to this court that the environmental effects that were faced in the state of Azania include the flooding due to the poor disposal of waste, the consistent occurrence of waterborne diseases due to these floods, and also the burning, which causes the pollution of the air, which causes the respiratory illnesses to the people of Azania. It is my submission to this court that despite, even without the adaptation of the TWCCA Act, the state could have taken measures to include the radical changing of this unsellable equipment by repairs and converting them into better equipment, better raw materials for the sake of being used in this country. It is also my submission that without the implementation of the TWCCA Act, the due diligence that the state of Azania should have, that the state of Azania had taken, is the conduction of these audits and the environmental reforms and scientific research, which established all these facts of the 35 to 45% of the unsellable equipment. Therefore, it met this threshold of preventing the imminent danger that would have been caused and was being caused by the organizations to the children of the Azania state. It is my submission.
Thank you.
Thank you. And so, Gloria, my question then would be, further clarification would be, in terms of what then shows in terms of the work that the state of Azania has done and the scientific evidence available to it, that there is that distinct probability or being able to foresee that there is the likely occurrence of harm, and perhaps what would be its magnitude and severity, so that we as a court can then be able to appreciate the level of harm vis-a-vis a situation where this law is not enacted, is not upheld, or found to have exceeded the reasonable bounds of.
Thank you so much, Your Honor, for that question. The reasonable bounds that are exceeded in this threshold by the importation of the second-hand apparel is likelihood of 35% to 45% of these goods being unsellable. They come in contaminated and oversaturated, meaning that they cannot be used further. And in any case scenario, without regulation of the importers and the northern states using the third world state as a global dam, it will lead to a huge rise of this dump, showing that many clothes will be deposited in the dams, in waters, causing the pollution of the marine environment by the microplastics. And also this will continue exposing the vulnerable populations, because we are told, according to the fact sheet, that 2.5 the population of Azania is engaged in this second-hand apparel, which consists of youth and women who are vulnerable in the society. And also, if this trade is not regulated and the TWCCEA Act is not enacted, it will continue leading to the consistency of floods, waterborne diseases, and respiratory illnesses when the harm is not regulated and when there is no threshold to ensure that the imports are surely good imports and not imports that will come and not be consumed in the country. Thank you so much, Your Excellency.
Thank you. I appreciate your responses. Presiding Judge, you can take over from there. No further question.
Thank you, Judge. My question goes to Joshua, a follow-up on your colleague's answer. From the fact sheet that 35 to 40% of the textile imports are actually go to waste. What amendments would you propose to the TWCCA to ensure that the state of Azania reduces the amount of probably waste that comes with the country, that goes to harm people at the coast, children, etc.?
Thank you, Your Excellency, for the question. I request the court first to go through the facts. 35 to 45 of the clothes, they go to waste, and this cannot be attributed to Azania as a nation. This can be attributed to the chain of distribution from the importer, from somebody who is the producer in the West, somebody is exporting these things until we reach the final consumer in the country. Therefore, one of the best resolutions and regulations that we can do, the first one is the polluter pay principle, according to Rio Declaration at Principle 16, which necessarily dictates that the one who pollutes should take responsibility. And the TWCCA has already dealt with that. Then the second recommendation is the EPR, the extended producer responsibility, striking a balance and spreading the responsibility to everybody, and the TWCCA has enacted that. So my recommendation will be for us to enhance climatic protection, and we must work together according to Paris Agreement Article 1 and clearly enforce the TWCCA Act, for it is the only remedy we have. Thank you, Your Excellency.
Thank you. That is the only question I had for Mr. Joshua of Azania. Judge Joki? Judge?
Yes, I'm present.
Are you there?
Yes, I'm present. Can you hear me?
I hear you.
Okay, excellent.
Any further questions?
Yes, I'd like to follow up on a question that Judge Theuri asked on due diligence.
Yes.
And so I'd like Mr. Joshua or Ms. Gloria, any of them, to confirm on whether the due diligence obligations can override trade obligations, or is it their submission that they must be reconciled? And if they must be reconciled, how then would Azania justify the reconciliation? So first, I'd like them to espouse to the bench on whether due diligence can override trade obligations, if they override or if they don't override. I'd like to hear that clearly, and whether this must be reconciled.
Thank you, Your Excellency, for the question. Our primary stand on this matter is that due diligence, in a strict sense, it does not override the economic reasons, the economic interest. However, Article 31(3) of the Vienna Convention mandates this court to interpret the GATT at Article 15, which provides for the right economic reasons, with Article 26 on the right to environment, 25 or UDHR on the right to life, Article 16 of African Charter and People's Right on the right to economic protection, Article 21 on the right to use the available resources well, then to use it also to interpret it together with Article 14 of African Charter on the welfare of the children. We'll come to discover that once we use all these things and we see there's a conflict and they cannot stay together, it means that one right must take a precedent over the other. And when life is used is in conflict with economic reasons, it's our submission that life should, or the right economic or the environmental rights should take precedence. However, the two can be reconciled. That's the second stand. The two can be reconciled, and we use the reasoning of Hungary versus Slovakia on the contractual obligations. Let us take these two things as a contract, and if every party fulfills its obligation, it means that there will be no conflict. And if there's no conflict, it means that these two rights can be reconciled and can be met all together. Thank you, Your Excellency. I submit.
Thank you, Mr. Joshua. No further questions for me, Judge.
Thanks, Judge Njoki. Thanks very much. Brother Eric, Judge Eric, are you there?
Yes, my lord. I'm there.
Any further any supplementary questions?
My lord, presiding judge, none at the moment. But my lord, maybe insofar as perhaps I would just want to understand from the state of Azania whether from their position, because when we're talking about issues of proportionality and the question of trade and the balancing of between the trade and the other socio-economic rights, including the right to livelihood, which is directly affected by some of the provisions of the Act, or that is the case that is before us. In terms of what is the position of the state of Azania with regards to the application of any principles of equity to this present case, and more specifically, the question of intergenerational equity, insofar as it relates to the protection of the environment, and I think that your position is that you are taking these measures for protection of children and the economic and the environment in the social areas to reduce the flooding and those other adverse measures that you have alluded to. But then again, when you look at the element of a significant portion of your population, as high as probably 40%, relies almost entirely on this apparel trade as their main mean of income. So when we are looking at issues of equity, and is there any measure that the state has proposed in the legislation to mitigate the impact on this significant population that relies on the trade apparel for their upkeep? So in a way, those are two questions. So that the first is in terms of the operations of the principles of equity in international law, and secondly, the other aspect of intergenerational equity and how then you seek to balance between that and the economic rights of your population.
Thank you, Your Excellency, for the question. I want to answer the first question in two limbs on equity. The first one in equity as an overall principle. The second threshold on intergenerational equity. Then I'll proceed to answer the question on population. The first one on equity. Your Excellency, I want to use the principle that who comes to equity must come with clean hands. And page 3 of the fact pattern, you'll come to discover that the impacts that were done by this environmental harm, they disproportionately affected children, coastal community, and future generations. Therefore, it is imperative that whenever who seeks equity from this court, it should not come with soiled hands. And it's our position that CECA comes to this court with soiled hands. Secondly, on intergenerational equity, relying on the fact on the same pattern, it is the submission of the Azania that the state has a positive obligation to promote, fulfill, and protect the children's right. We rely on Article 14 on the principle on Article 14 of the Africa Charter on the welfare of the children that allows this court to take necessary measures that protect the children to the greatest extent. Also, Your Excellency, the UN advisory opinion on Article 24 of the Convention of the Children's Right says that the government must take necessary steps to protect the children's health and the children's life. From the fact pattern, we can observe the children at the coast being threatened by the marine pollution, the children on the land being threatened by flooding, the children even at the rural areas being threatened by respiratory diseases. Therefore, a state has a positive obligation to protect the current and the future generation. We buttress that argument by the Pearl Mills case that established the case that we must use the resources which are available to protect international community. It is our interpretation that international community does not just involve the current generation, but also the future generation. On the second limb of your question, on the population and the economic, we are relying on the economic in this second and close for economy. Your Excellency, I want to invite the court to the kind of measures that were taken, because it is the submission of the Azania that these measures are not disproportionate in any way, they are not discriminatory in any way. The first measure which was taken, it was to introduce extended producer a responsibility that have illustrated in this code, and it is equitable and it promotes justice. The second one is establishing the minimum quality of the goods that they need. Your Excellencies, is it discriminatory for a state to give the minimum standard of the clothes that they need? We find this that this is state sovereignty according to UN Charter Article 2.4. Then the last one is registration and certification. This does not push anybody out of the economy. Then secondly, Your Excellency, we rely on Article 25 on the right to health and the right to health. The 2.5 million people who are relying on this economy, they form part of the 48 million people that the state wants to protect. Even if we go the utilitarian way, it is imperative to protect 48 million people, not the individual need of 2.5 million people who are violating the environmental right. Thank you, Your Excellency, for the question. I submit.
Thank you, Presiding Judge. I have no further question for this team.
Neither do I have further questions for this team. Our court clerk, how much more time do they have?
They have 14 minutes to go.
14 minutes to go.
Judge, I propose maybe you could go to the CECA side, and then those 14 minutes they can add to their submissions.
Yes, I agree. CECA?
Yes, Presiding Judge.
Yes. Nick?
Yes, Your Excellency.
You're the lead counsel.
Yes.
Is that right?
Yes,
Thank
affirmative, Your Excellency.
I just go to the basics. The fact sheet as well as the ICJ opinion raised two issues, fundamental issues: the responsibility of a state on matters environmental and the consequences. My question to you is this: what did Azania do that was not in compliance with the principal instruments on climate change mitigation and adaptation and mitigation?
Much obliged, Your Excellency. To respond to your question, allow me to first start by reaffirming the principle of due diligence. This particular principle has been affirmed by the advisory opinion of the ICJ, as you've just mentioned, that it is, as a matter of fact, an obligation of conduct. What this means to this honorable court is that they are required to take certain measures and steps as explained by the precautionary and the prevention principle in order to ensure that significant and transboundary harm does not occur on the part of the environment. Seeing that they failed to take such measures is enough justification before this honorable court that they failed to ensure they have upheld this obligation of due diligence. Looking at the fact pattern, Your Excellency, for 3 decades, the state of Azania has become one of the world's leading importer of the second-hand apparel. This has resulted out of that import that 35 to 45% is unsellable. For 3 decades, they have not taken any steps as prescribed and recommended under the obligation of due diligence and the principles of prevention. They have not taken any steps to ensure that the 35 to 45% of the second-hand apparel that is unsellable does not occasion any harm on the environment. But the fact pattern clearly lays out there is pollution which is disproportionately affecting vulnerable groups such as children, women, and the coastal communities of the state of Azania. And these omissions orchestrated by the state have, as a matter of fact, constituted to failures to uphold this due diligence that we are speaking of. I hope I have responded in a satisfactory manner to your question.
Follow-up question on that. What do you make of that legislation, the TWCCA, when you say that they have not taken any action?
Much obliged, Your Excellency. The position that CECA takes with regard to the TWCCA that has been implemented by the state of Azania is that it is disproportional in the sense that they are requiring the small scale and informal traders to apply the same identical measures and policies as the multinational operators. This particular aspect was noted in the case of the United States imports of shrimp and shrimp products to be a conspicuous flaw. The conspicuous flaw that is being spoken of is the coercive effect that is created by the need to apply identical measures cutting across the board, having failed to take into account the specific circumstances of each and every party or actor. In the state of Azania, the second-hand apparel trade employs 2.5 million people, a figure which is predominantly constituted by small-scale traders. However, the TWCCA, in a discriminatory fashion, goes ahead to require them to apply the same identical measures and policies as the multinational operators. This not only violates that principle and is not only noted as a conspicuous flaw, but it goes ahead to depart from the chapeau of the General Agreement on Tariffs and Trade, Article 20, where it sets 2 conditions that it is not to be, the of measures is not to be a discrimination to trade or an arbitrary and unjustifiable discrimination, and it is equally not to be a disguised restriction on international trade. And we humbly submit that is the position that CECA takes with regard to the act implemented pursuant to the ICJ advisory opinion.
That'll be all for me at this point. Judge Njoki?
Yes,
Sister Njoki?
yes, present.
Yes, please.
Mr. Nick, you've argued that I've heard part of your argument is on the proportionality. with an inclination to say that the law goes too far, despite the clear evidence of environmental and climate harm. How you and your co-counsel are applying the proportionality test here?
Much obliged, Your Excellency. In response to the question that you've fronted, I will be doing a great injustice before this honorable court if I were to go without mentioning what was stated by Judge Wiramantri in the case of the Gatikovo Nagimoro's case, where he stated that there must be a balance that is struck between the environmental considerations and the developmental considerations by the respective parties. Inasmuch as there is evidence, or rather information, that was tabled before Parliament, what is not being mentioned by the state of Azania is the unproportional, rather the disproportional burden that is being placed on the small-scale traders. But allow me to make reference to the Brazil retraded tires case, where the necessity test was established, in that the question that is being asked and the question that needs to be answered is, are less trade restrictive means that exist that would equally achieve the same objective? And the response that CECA has to this question is that indeed, yes, there do exist less trade restrictive means that can bring about the same objectives that they are seeking to achieve by this act. The said the less restrictive means include, one, the implementation of a proper waste management system, and is to additionally add that there can be checkpoints upon the imports to ensure that these 35% to 45% that are unsellable can be put to other use. The fact pattern clearly stipulates that they are not unusable. It is only that they are not of merchantable quality. Allow me, Your Excellency, to make reference to some examples where waste is being put to other use. Germany, for example, is leading in this category, whereby it is recycling 65% of its waste, and it is using it as other means through the producer responsibility and a system known as the green dot system. Equally, Your Excellency, South Korea is leading in this category under the food waste, whereby 90% of its food waste is being converted to bioenergy, therefore resulting into quite a benefit to its economy. And as such, we also want now to come to the present case that is before this honorable court, where it is our position that there exists less trade restrictive means that can achieve the same objective that is being intended by this act. And as a result, it is therefore unnecessary and fails the necessity test as established in the Brazil retraded tires case.
Thank you. I just want to get this very clear. So on the specific claim of proportionality test here, are you arguing suitability, necessity? What is your actual argument?
Our argument is that it is disproportional on the part of the second-hand apparel trade.
So on that disproportionality, which specific claim of proportionality are you saying this law is not suitable? Is it the necessity? Is it imbalanced? Is it unnecessary?
Yes, Your Excellency, thank you for your question. It is both unnecessary and unsuitable for the present case. It is unnecessary as it fails the necessity test as established by the Brazil retraded tires case that I have brought to light before this honorable court. It is equally unsuitable because the report as per the Center for Climate and Energy Solutions as of 2023 indicates that waste contributes to a mere 4% of the greenhouse gas emissions. However, we have other aspects such as the power industry and the industrial combustion as well, which are leading with 29% and 21% respectively. As a result, it therefore defeats logical sense that the state of Azania goes ahead to implement the TWCCEA, which targets discriminatorily so the second-hand apparel trade and leaves the larger 96% unaddressed, therefore begging the question how they seek to achieve the reduction of greenhouse gas emissions while they have done nothing with 96%.
Thank you. No further questions from me. Over to you, Judge.
Thanks, Judge Joki. Brother Judge, Eric?
Thank you, presiding judge. I will go to the team for CECA. If I were to say that this court has a discretion to decline to issue an advisory opinion, even where the conditions of jurisdiction are met, would you first agree that that is a proper exposition of the law? And if you agree, what do you think should be the reasons for this court to take up its jurisdiction and give the advisory opinion you have sought, if indeed we can actually decline to exercise that discretion?
Counsel, did you hear the question?
Pardon, Your Excellency.
Did you get a question from His Excellency Judge Theory?
I would kindly like to request that he is so pleased if you could pardon the question.
I could repeat the question. So I'm basically making an assertion that whereas this court may have the jurisdiction to give an advisory opinion, it does not always mean that this court must exercise that jurisdiction. So that would you agree with me that this court has the discretion not to give an advisory opinion, even where the conditions for the grant of an advisory opinion are met? And if you agree with that statement, then what would be your reasons to urge this court to take up its jurisdiction and give the advisory opinion as sought, even though both yourselves and I think the state of Azania are somehow at an agreement that this court has the jurisdiction to issue the advisory opinion that has been sought?
Much obliged, Your Excellency, and thank you for your question. First and foremost is to cite Article 96 of the Charter of the United Nations, and in a similar note to also bring to light Article 65(1) of the Statute of the International Court of Justice, where we are informed that upon the request of any body that may be authorized by or in accordance with the Charter of the United Nations to make such a request, the court may indeed give an advisory opinion. Noting that through the nuanced reading of that provision, the word may is used, it will then follow that you are indeed at liberty to decline to render an advisory opinion, despite the fact that this court has the jurisdiction to do so. On to your second question, Your Excellency, as to why we'd request that you render the advisory opinion, it is for the simple reason that this is a matter of law, international law that has been reaffirmed previously and at certain instances before this honorable court as well. Therefore, seeing that that condition has been met, we would now like to submit that following the court's jurisdiction and as reaffirmed by Article 65(1) of the Statute of the International Court of Justice and 96(1) of the United Nations Charter as well, we would now submit that this court be pleased to render an advisory opinion as requested by the United Nations General Assembly.
Thank you for that question. For that answer to my question. I am well guided. Just as a follow-up, and this you can take or your co-counsel can take, in terms of issues around sovereignty and undeniable right of the state to legislate, and we say this because of the issues arising from the principles of due diligence. which imposes a duty on the state to take actions to prevent any environmental harm within its territory. The jurisdiction of the court, which you have clearly stated, that we may decline to give that opinion. Do you think to your mind that there are any compelling reasons that then would prevent this court from giving an advisory opinion in view of the element of sovereignty and the fact that the duty under international law to take action to prevent environmental harm within the state is actually a sovereign function? So it's just a follow-up to that question and can be answered by any of your team, any of the councils in the team.
Thank you, Your Excellency, for that question. We are indeed cognizant of paragraph 281 of the ICJ advisory opinion that provides states do, as a matter of fact, have the obligation through their national systems of enacting legislation and administrative procedures followed with enforcement mechanisms to enact such an act as the TWCCEA. However, allow me to bring to light before this honorable court Principle 2 of the Rio Declaration, which I will read verbatim. States have, in accordance with the Charter of the United Nations and the principle of international law, the sovereign right to exploit their own resources pursuant to their own environmental and developmental policies, and the responsibility to ensure that activities within their jurisdiction or control do not cause to the environment of other states or of areas beyond the limits of national jurisdiction. Following the reading of this particular provision of the Rio Declaration, Your Excellency, what comes to the mind of this court is that this sovereign right is not absolute, that it is pegged on certain aspects such as their own resources and the environmental and developmental policies. Looking at the fact pattern and how Azania is described, it is just but a developing state whose environmental and developmental policies are not fully matured and realized as opposed to those of developed states. Therefore, we now come to this court taking the position that the TWCCEA is not consistent with the provisions of international law as it is disproportional in its very nature. I hope I have responded to your question, Your Excellency.
Yes, you have. Presiding Judge, I have a follow-up question.
Please, fire.
Following that response, and my question then to the CECA team, legal team, would be whether in view of paragraph 281 that you have just alluded to, and the responsibility of the state, whether indeed you the clients that you represent in terms of the interest that you represent, and those are the various players within the circular model, whether those can be then seen as legitimate governance actors, governance actors or state actors, then this duty that reposes on the state can be imposed on them insofar as appropriate measures for mitigating environmental harm is concerned, or those are outside the limit of the appropriate actors, and so therefore that that act would have gone outside the scope of the responsibility that the state has to take appropriate measures. I don't know if my question is clear.
Allow me to, in an attempt to clarify, if you are referring to whether the paragraph 281 of the advisory opinion is specific to government actors or it extends beyond to other actors. Is that the
Yes,
case?
yes, that is precisely my question. My question would be whether your position would be that these actors within the circular economy can be equated to governance actors that then can be given that responsibility, because as we have seen, there's a responsibility on the state. So can you equate them to that level so that then they then have that responsibility reposed on the government to implement those measures?
Thank you. Thank you for the question, Your Excellency. Equally for the clarification. I've seen my co-counsel Timothy as indicated would
Thank you, Your Excellency. Allow me to take this matter on the question that you have asked in respect to whether the social enterprises can be recognized as governance actors in the circular economy model, and in specific reference to paragraph 281 that you have mentioned. On this matter, it is the submission of the coalition of ethical circular apparels that the exclusive recognition of social enterprises as governance actors is illegitimate and an unlawful regulation. Under the international law, specifically the Inter-American Court on Human Rights, while states may involve actors, it is only possible if the implementation is based on integral manners. And also this is recognized by Judge Hsu in the advisory opinion, separate opinion in the obligations of states in respect to climate change obligations, where she notes that it is imperative for the court to recognize and adhere to the mitigation and adaptation measures that must be done in an integral manner and in respect to economic and social conditions. The implementation of this, or the attempt of the Act, the Textile Waste Control and Circular Ethical Apparel Act, to recognize social enterprises as governance actors is also contrary to the case that was established in the Milieu de Facio et al. Versus the Royal Dutch Shell Company, where it involved a non-state actor and it framed the corporation as a subject of the law and that must be ordered by the court to comply with human rights obligations. It is therefore the coalition stance based on this case that private and social enterprises are entities to be regulated by the state rather than entities that actually exercise governance authorities themselves. Furthermore, in paragraph 262 of the advisory opinion, the ICJ advisory opinion of 23rd July 2025, the court noted that states are free to select the means of cooperation, and the Paris Agreement also highlights this as long as such means are consistent and are consistent to the due diligence obligations of good faith and responsibility. If we look at the recognition of these governance actors, they appear to be portrayals of political patronage rather than necessary and good faith obligators. And the reason as to this is, as mentioned before, on the international best practices that have been identified in other states, including Brazil and India, where they have adopted SEWA models that include informal actors rather than replacing their livelihoods and criminalizing. Legitimizing these governance actors is creating a state-sanctioned monopoly, and through this, it is because these governance actors delegitimize existing informal workers who are historically described as managing the circular flow of apparel. And with that, Your Excellency, it is our submission that the recognition of certified social enterprises is unjustified and unlawful in the circular economy. I hope I have answered your question, Your Excellency.
Yes, very satisfactory. I don't have any further question, Judge.
It sort of worries me to the extent of your answer is a local entity within the jurisdiction of Azania. How would its activities within the jurisdiction of Azania affect downstream states that are not subject to the same law?
My apologies, Your Excellencies. I'd like you to clarify on whether you are inquiring about the effect of the coalition on the jurisdiction of the state or on the ethical circular apparels.
The answer you seem to give to the court suggests that sex activities affect the well-being or ecosystem of a downstream state, whereas it is purely a local group or coalition that deals purely in textile apparel. Is it a governance body?
Thank you, Your Excellency. The coalition of ethical circular apparels is not the governance body. It is one of the stakeholders, pardon me, Your Excellency.
Go on.
As I was saying, thank you, Your Excellency. It is one of the stakeholders in respect to the circular economy. And the coalition of ethical circular apparels involves informal actors of around 2.5 million people, majority of whom are women and children who are the vulnerable populations. Allow me to turn to the principle of the Rio Declaration, Principle 20, 21, and 22, that make reference to the vulnerable population groups that should be incorporated during the just transition to a green climate energy solution. They recognize women, that is Principle 20. Principle 21 recognize youth, and Principle 22 recognize the indigenous people. Therefore, these stakeholders now, the women, the youth, and the indigenous people, are the informal collectors who should be incorporated into the Circular Economy Act, rather than legitimizing stakeholders such as the social enterprises, because the social enterprises will not bridge the gap between the informal sector and the formal sector. And the Just Transition Principle by the United Nations Economic Commission for Europe provided that a just transition entails a transition that leaves no one behind and promotes participatory governance, which is also reiterated in Principle 10 of the Rio Declaration. That is my submission, Your Excellency.
Thank you.
Yes, I have
any
one
other-
more. Yes, I have one
Thank
more
you.
question for
Yes.
the SECA team. To either of them, how would your position in this matter ensure meaningful climate action is still achieved in practice? So I want to know how will your position affect the climate changes that are still happening due to this import exportation of second-hand apparels?
Thank you, Your Excellency, for that question. It is only proper for me to answer that question by first reiterating what was noted by Judge Xu in her opinion at the advisory opinion in respect to climate change. And she recognized that climate change appears to be an environmental measure, yet it is a question of development, because the achievement of the 1.5 degrees Celsius objective, which is a global action on mitigation of the greenhouse gas emissions, which likely affect almost every economic sector of states and every aspect of our way of life. And it is therefore only proper to say that the climate change obligation issue can only be tackled in an integral manner and not in a sectoral approach, such as infringing or restricting international trade, as is seen by by imposing the Textile Waste Control Act. And therefore, it is imperative for the courts to consider mitigation and adaptation measures that must be done in accordance with economic, social, and cultural rights, together with sustainable development that is also provided for under the United Nations Framework Convention on Climate Change, Article 3, and also the Rio Declaration. And with that, Your Excellency, as the Coalition of Ethical Circular Apparels, it is our submission that the state has a right to ensure the environmental protection is done. But as was mentioned before, the environmental protection should be balanced together with economic development. and this includes sustainable development. Therefore, it should incorporate the informal actors and provide for bridging gaps that will not leave those informal workers who do not have the digital infrastructure to access the trade, and who are the majority of this population. Thank you, Your Excellency.
Let me just do a follow-up on that. I mean, that sounds good in principle, but could you give us specific measures in your approach that can give directions on the reduction of emissions or waste reduction in ways that are measurable? So let's move from the principles and now let's get to actual measures that can reduce emissions and reduce the waste reduction.
Thank you, Your Excellency, for that prominent question. On the practical side of this, the necessity test requires that the measure, any measure that is to impose an exception to the general agreement of tariffs and trade under Article 20 has to be compared against a less trade alternative. Now, the practical implications that the CECA provides is alternatives such as the waste management investments, where evidence shows that textile waste accumulation exacerbates flooding and waterborne diseases in informal settlements. Investing in improved municipal flooding and waterborne diseases and municipal waste collection and processing infrastructure would address this harm without burdening the informal actors who now have to bear the burden of the digital traceability requirements that is so sophisticated, first of all, and it is very resource intensive. Another measure that could and would have been imposed that could have helped achieve the same environmental objective is the point of entry qualification inspections. This point of entry quality inspections, rather than comprehensive EPR and digital tracking requirements, would have implemented targeted inspections at the import points to identify and reject unsellable garments, directly addressing the documented 35 to 45% waste rates without imposing capital-intensive policy and tracking requirements over the garments. It is my prayer I've answered your question, Your Excellency.
Yes, you have, Council. No further questions from me, Judge.
Much obliged.
Follow up on that question, Judge, with respect Council's answer that you need to have an inspection at the point of importation or at the point of consignment. And supplementary to that, who would bear the cost of such inspection?
Thank you, Your Excellency. As I articulated before, can be done at the point of import and not consignment. And this would distribute the costs to all the informal actors rather than imposing a digital tracking requirement that would impose these costs to each actor, and it is very resource intensive, requiring infrastructure that is not easily accessible to these informal actors. And therefore, imposing this point of entry quality inspections at the import sector will be able to target the waste at the upstream level rather than moving and waiting for it to reach the downstream level where it is not easily accessible.
Council, just for the future, not for this discussion, but for the future, just make a bracket note. Importation of sugar, close bracket. Thank you, Council.
Much obliged.
Judge Theory. Brother Theory?
Judge, I have no questions, no further questions for this team.
Thank you. Court Clerk Birundu, how much time do they have left, if any?
They have 6 minutes to go.
Minutes to go. Can put that for them at submission level. There'll be no further question from me. So we go back to Azania. Azania, final rebuttal, response.
Thank you so much, Your Excellency, for these opportunities. As presented by the concepts
Sorry
of
to
the
interrupt. Just a second.
of discriminatory
Yeah,
on
sorry to interrupt. I just need to make you aware that each council will have 7 minutes for the rebuttal.
Thank you.
Gloria, you are muted. Gloria,
Gloria?
please unmute. Gloria, can you hear us?
Gloria, kindly unmute. Unmute yourself. Gloria, she can't hear us. Joshua, can you tell Gloria to unmute?
Joshua?
Joshua, are you in
Please.
the call?
I don't think they can both hear us.
Joshua, are
Maybe
you on the
drop
call?
an info message.
Okay, let me call them.
Yes, I don't think they can hear us.
It appears their network might be fluctuating.
Yes.
We cannot hear Gloria.
And she's submitting.
She is.
It's very interesting.
Because our camera is on, but we can't hear her.
Joshua, we can't hear you. You're muted.
Oh, thank you, Your Excellency, for the opportunity.
Joshua, Joshua, kindly, we didn't hear Gloria. She was muted all along, yourself as well. So we need you to check your internet and ensure your connectivity is stable. So can Gloria just repeat her submissions because we didn't hear anything?
Thank you so much, Your Honor, for this opportunity. Apologies for being muted. It is my submission to this court that according to the submission of the councils of CECA on discrimination on the basis of the adaptation of the TWCCEA Act, that it discriminated against the 2.4 million population of the people of Azania. It is a submission that according to the pulp mills case on River Uruguay, that the duty of due diligence is an ongoing responsibility and must be assessed according to the uniqueness of each circumstance and according to the uniqueness of each case. It is also my submission to this court that in light with the circumstances of this case, that the state of Azania is a lower middle income state, and it has been experiences the atrocities of this second-hand apparel trade, the flooding and the consistent witnessing of the respiratory illnesses of the people. Therefore, the adaptation of the TWCCEA Act was non-discriminatory and was compliant to the duty of due diligence. It is also my submission to this court that the councils of CECA submitted on the disproportionality of the adaptation of the TWCCEA Act. It is and relying to the Gabsikovo case. It is our submission as the councils of Azania that relying on the same case, that the state of Azania in adapting development and should in the same case rely and pursue the ecological sustainability. Therefore, it is our submission that the state of Azania in adaptation of the TWCCEA Act was acting to the imminent danger posed by the second-hand apparel trade, bringing the violence into the state of Azania. I rest my case.
Thank you, Your Excellencies, for the question, to the opportunity to hear me again. To my final rebuttals, I'll start with the most controversial thing of the bull's head in this case, which is discrimination. Your Excellencies, we want to submit that the polluter pay principle is not discrimination. What Azania did is just to tell somebody who benefits from environmental pollution to be accountable for what he is doing. Then in my excellencies, it's a submission that not every differentiation amounts to discrimination. It is what, and it's a submission that what happened here, it is differentiation, and positive differentiation does not amount to discrimination. That's why even at South African Constitution, Article 9, which you want to use persuasively, has introduced concepts like positive discrimination. Also, Your Excellencies, in any case Article 15 of the GATT introduces exceptions to discrimination rule. And one of the exceptions to discrimination rule is when the benefits that are contemplated outweigh the injury that can be caused. This manner, it can be allowed. And the question which we pose to this question, do are the benefits we have vis-a-vis the kind of injury that we have? The benefits we have is protecting 48 million people. The benefits we have is protecting the lives of even these second-hand apparel traders, protecting even their children, protecting the country. And what is the injury that is caused? The injury that is caused is merely saying that we need minimum for the clothes that you are importing. And also, Your Excellencies, the CECA relied on the Brazil retreated tires case. It's our submission that this case favors our side even more than better than favors our side better than their side, because this case established the principle that public concerns and public health can justify limitations of economic rights as long as they are not arbitrary. So the question we should ask, was it arbitrary? Arbitrarily, this means that was the law followed? And it's our submission that there was public participation because the legality of the tweaker has not been questioned. There was peer review by scientific report. There was court where they were given a fair trial, and this is reflected by Article 14 of ICCPR, also reflects the spirit of the Magna Carta, Article 12, that say that no one can be punished unless is given a fair trial by his peers in the society. Also, Your Excellencies, the argument of less restrictive means is our submission that their model fails. Why? Because they give, number one, they give resolutions that are progressively realized. And in our case, we have imminent danger that calls for an imminent solution. So which means if you got with their model, by the time you're going to realize the goods of their model, the imminent danger would have occurred. They would have lost a lot of children, a lot of lives, and a lot of respiratory diseases will be occurring in the country. Also, Your Excellencies, the case of Costa Rica established that due diligence increases when harm disproportionately affects the marginalized and the children and the vulnerable. And from the fact pattern, we can see it affects children disproportionately and the marginalized. Also, the model they give you on less restrictive, they give you an example of Germany, and they give you an example of Germany. Your Excellencies, we can only use this by distinction. This is a first world country, and yet Azania is a third world country. This will dictate that the first world country has a lot of materials, a lot of resources, and it can do all things. But according to the peculiar and the pragmatic realities that exist in Azania, these things cannot be achieved. Also, they give things like checking things, they give remedies on checking on the entry point and everything. And it's our submission that the extended producer responsibility achieves that. We want to achieve by better grading, and these things are going to be done. So in essence, what they're arguing is that we should follow the tweaker. Also, they argue on development. It's our submission that there are no development done by the coalition. It is called the violence of development. Raja Paul, in his works, want to rely this by virtue of Article 38 of ICJ Institutes of using great scholarly work. And Raja Paul, in his work of violence of development, he demonstrated that some development are not just developed, they are just atrocities and violence disguised as development. And we can observe that from the case of Ogoni in Nigeria. We can see from the Talo case, which people disguise the mass violation of human rights and economic rights, the economic reasons to justify that. Then, Your Excellencies, lastly, is economic protection, which is also a very great and essence debate here. It is our submission that we are not pushing anybody out the economy. In fact, we are incorporating. And what is the economy? Economy involves the agriculture sector.
Excuse me,
Yes,
sorry to interrupt. Your time is actually up.
Good. Thank you, Your Excellencies, for the time I submit. Thank you.
May it please this honorable court, Your Excellencies and presiding judge, we would like to move to our submissions.
Right. Yes, proceed.
Thank you, presiding judge. Learned counsels for Azania have fronted certain arguments to this court that I would like to address. They have informed us of the benefits versus the harm that stands to be suffered in their attempts and efforts to justify that the TWCCEA is in fact not occasioning any discrimination. However, in their attempts to do so, what they are informing this court is that the environmental protection and economic development should be looked at as if they are mutually exclusive. However, this, of course, we know is not the case, is not the factual position, as Gapchikovo-Nagimoros informs us that a delicate balance need be struck between these two to ensure that in the context of sustainable development, the two can be addressed. Similarly and equally, we are informed that none of these two, none of economic development and environmental protection has been given absolute authority over the other. This is to inform us that whenever we are talking of one of them, we must equally, on the other side, consider the other. Secondly, Your Excellencies, they have also continued to inform us of the polluter pays principle, which we affirm. And in furtherance, we posit to this court, in addition, we would like to refer to the principle of the common but differentiated responsibilities, which in and of itself is a principle of equity. Looking at the source of this second-hand apparel trade, which stands to be the global north, where we have developed countries as opposed to Azania, which is but a developing country, it is posited by the preamble of the Paris Agreement that there is an intrinsic connection that exists between climate change and response to climate change and sustainable development and the eradication of poverty. Azania, as it is, does not have the resources and infrastructure to address the adverse effects of climate change. This is the very reason why we have populations in the state of Azania suffering disproportionate effects. If we were to attribute the burden of addressing this problem to the global north, who are actually the cause of this, the source of the problem, if we were to meet the problem at its source, we would like to posit that it is in the best interest of this present case that we don't find ourselves doing what is probably referred to as cutting the weeds at the stem rather than uprooting the roots itself. It would have been best in the reaffirmation of the polluter principle that this burden, in light of the principle of common but differentiated responsibilities and the polluter pays principle, that it is occasioned on the shoulders of the global north. So doing, Your Excellencies, I'd like to cede floor to my co-counsel who will conclude on our submissions.
Thank you, Your Excellency. As I take on the last part of our submissions, Azania has framed itself as the wise builder who is waiting on the rock, which is the text, the ICJ advisory opinion, providing for the stringent due diligence obligation so that use it as an excuse to impose an act that is a protectionist measure in the name of an environmental measure that balances sustainable development with economic development. Your Excellencies, Azania waited for 3 decades before imposing measures that can mitigate the circular ethical apparel trade. Due diligence obligation requires good faith and conduct. A prudent state would not wait for 3 decades to impose measures, but rather even after the first year, a state would impose measures that would mitigate this harm. We are being told by the scientific fact pattern that women and children have been affected by the waterborne diseases. Principle 13 of the Rio Declaration requires states to develop national laws regarding compensation for victims who have been affected by this trade. Instead of doing this, the Republic is more keen on developing on denying the 2.5 million people their livelihoods through measures that are unachievable, unsustainable. They do not satisfy the necessity test which we have put across and they do not, they also fail the proportionality stricto sensu test because the measures imposed and the obligations are not equal and they are not balancing in nature. Accordingly, the National Center for Biotechnology Information Social Factors such as poverty, National Center for Biological Technology Information recognize that factors such as poverty and lifestyle changes are moderators for the mental health effects on women and children, most prominently in low middle income coastal states. More than 80% of people living in the world reside in low middle income coastal states and are affected by mental health. By imposing these measures, the state is actually increasing the mental health of these 80% people. And according to research, 4.61 per 100,000 have suicide rates.
You're muted.
My apologies, Your Excellencies.
Thank you.
As I rest the submission of the Coalition of Ethical Circular Apparels, Azania maintains that this measure applies a uniform standard for circularity to all market participants. However, this court must consider the warning that was given by Anatole France. The law in its majestic equality forbids the rich as well as the poor to sleep under the bridges and to beg in the streets and to steal bread. In its majestic equality, this act forbids the multinational corporation and as well as the informal street vendor from selling and accessing the market without a digital passport and prohibiting them from attaining the ecosystem of the circular economy. While this law appears equal on its face, it realistically actually criminalizes the survivalist initiatives of these 2.5 million people who have no alternative but to work within the informal circular economy model. Azania argues that according to the common but differentiated responsibilities principle provided by the United Nations Framework Convention, that they did not have the administrative capacity to legislation before the of the respective obligations of state advisory opinion. However, the International Law Commission recognizes that the lack of administrative capacity is not a sufficient excuse for a state to fail to implement measures. And with this, the Coalition of Ethical Circular Apparels invites this court to clarify that states have binding obligations under international law to regulate climate harmful binding chains, including transboundary apparels, but such regulations must be proportionate and non-discriminatory and must not unduly impair circular economy actors. Secondly, we invite this court to clarify that. Thank you. And with that, we yield the floor back to the bench.
Thank you. Judge Njoki?
I'm present, Judge.
Any clarification?
None from my end. Thank you.
Thank you. Brother Judge, Excellency Theory?
I'm allowed no further clarifications from my end.
Thank you. There will be none from me too. Back to court clerk and moderator.
I think that marks the end of the submissions for both sides. I will now respectfully request the honorable judges to retire from the public courtroom and proceed to the chambers for deliberations. As for the rest of us, kindly remain on the call as we await the return of our honorable judges. Thank you. So I'll just be giving you the comments. We can start with Egerton University. I'll begin with Gloria Oguel. So there's a noted improvement in your work. You're quite attentive and articulate, but at the same time, your confidence is a bit questionable. You don't appear very confident, but otherwise your content is okay, and you need to work on your presentation as much as your content is okay. And your thought process appears to be a bit vague, so you need to learn how to make that a bit more clear. That's all. I'll move to Joshua Kebati. You've been noted to be very expressive. You have a good command of the subject. You have good communication and advocacy. You appear to be very confident in your speech, to be very passionate. You need to try to speak a bit slower for more articulation. So it appears as if you're rushing when you're trying to do your deliveries. So moving on to the Catholic University of Eastern Africa, I'll begin with Nick Kimathi. You've been noted to be very poetic. You have a lot of potential. You're very expressive in your work. You're very composed and well-structured. You have good advocacy skills, and you're easy to understand. So you're very confident. You appear to be very confident. Or Timothy Kamore, you have good potential. You're also quite composed. You looked like you understood the subject. You have good structure. You have good delivery, and you are enjoyable to listen to. Actually, the choir team is noted to be quite enjoyable to listen to. So good job. That's all. So I can now hand over to the presiding judge for the final remarks.
Seems the presiding judge is not yet here. He's having challenges with his network. Just give him a second. Judge Eric, will you step in? For the interest of time, will you step in?
Yes, I can. So first of all, may I congratulate all the teams for a very able presentation. It was not easy in our deliberations, although someone had to emerge a winner, as they say in any football match. Sometimes there always has to be a winner, and the person who scores always emerges the winner. Sometimes they may not have had the best of play, but there has to be a winner. So in what we were looking at is a complex marking scheme where we were looking at how you exhibited understanding of the law, your knowledge of the law, how you applied that law and the analysis of it, the structure of your arguments and the clarity of your arguments. We tried to assess your advocacy skills, your use of authorities, and how responsive you are to the bench. And basing on that, the final score, consolidated score that we gave to the teams is that we gave Egerton, representing Azania, 70%. And so therefore, the winners of today's contest is the Catholic University, representing CECA, whom we gave 80%. Before we pen off, may I give an opportunity to counsel, the lead counsel for Azania, to make any comments that they may have to the bench, and then we'll go to counsel for CECA.
Thank you so much, Your Excellency, for this opportunity. It has been a nerve-wracking edition, a learning experience, and it was so honorable to present before all the honorable judges. Thank you, and congratulations to the winning team.
Thank you so much on behalf of CECA, Catholic University.
Yes, Your Excellency, I believe I speak for my counsel, Mr. Kamore, when I say we are more than honored to have appeared before you today. And we also want to extend congratulations to counsels for Azania. We note that it has been a challenge. My co-counsel and you continue to challenge us, and we are very grateful for this opportunity to have been present in this wonderful platform and forum to continue learning. And as we all grow into the industry of the law, in this case, international environmental law and the practice of the same, we hope that we shall continue to cross paths and we shall continue to learn in the same way and fashion. Thank you.
Thank you so much on behalf of the presiding judge and co-judge Judge Njoki and myself. We want to thank you, the advocates who appeared before us, court clerk and the secretariat behind the team for enabling this wonderful experience. We want to just urge you that we have seen a lot of potential, a lot of improvement, but we understand that you are at the stage where you are developing to be lawyers. But what we have seen is that the future in terms of environmental law and advancing environmental law and practice is very rich in your able hands and in terms of the work that you have done before us, and we encourage you, whether you have won today or not, to keep maintaining those standards, to look at your presentation and to see areas of improvement, because all of you have immense potential. I would want to say, and I think that this is a comment that is shared between myself and the fellow judges, that listening to you, we have learned something. Listening to you, we have been challenged in different ways, and we live here having learned quite a bit from the manner in which you presented yourself, from the manner in which you simplified extremely complex and intertwining principles of international law that requires you quote authorities and precedents from diverse countries, which is a bit different from what we ordinarily do in court, and we were extremely impressed by that. Having said that, I guess then that marks the end of this court session. The court clerk, in the event that there is no other business, then you can direct us as to how we finalize with these proceedings, but the formal court session is now officially over. Thank you, ladies and gentlemen, counsel, for appearing before us today.
Thank you very much, Senior Counsel Eric. I believe you can hear me. Apologies, today I was caught in the rains and I had to just stop at the closest hotel to do this thing, but I'm very grateful. The semifinals, so Catholic University, you join Jomo Kenyatta University, you join Herbert Chitepo, and you join University of Zimbabwe in the semifinals. Semifinal one will commence on the 30th of April at 17:30 hours, same place, same link, between and Catholic University representing Azania. That one will be on the 30th of April. And the second semi-final will be on the 2nd of May. Second between Herbert Chitepo representing CECA and University of Zimbabwe representing Azania. As we indicated, the format for the semi-finals will also change. And with that, we shall send you the communication shortly after this so that you know what to expect for the semi-finals, so that you can prepare for them tomorrow. Otherwise, we are grateful for all this. Presiding Judge, I see you are back. Let us give you the opportunity to close the meeting for us.
I have enjoyed working with my fellow judges. I've enjoyed working with the council, and I've enjoyed working with the secretariat. Congrats for setting up the exercise Moot Court, and I really wish very, very good to the burgeoning environmental lawyers, because that's what this country needs, and that's what Africa needs. Thank you very much. Congrats the winners, and equally today's second runners-up. Asante sana, na Mungu akubariki.
Thank you very much. As usual, you shall have your evaluation rubric by tomorrow morning to see how you scored and where you can improve. With that, if there's no other issues from the bench, then we are free to leave the platform. Have a good evening. See you on 30th of April.